My mom recently passed away, and I just discovered that she put me in charge of her living trust. I'm not sure what are the first steps I should take. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. You need to first accept the responsibility or the nomination as the successor trustee of your mom's trust. This can be done on a formal document known as acceptance of trusteeship, a certificate of trust, or it could be done by virtue of your actions. A written acceptance of trusteeship or a certificate of trust may be necessary to give to financial institutions to prove that you have the authority to act as the successor trustee. If you're like me, once you're introduced to new concepts, you want to make sure you understand the key terms. So let's take a look at the term settlor. The settlor is the originator, the creator, or the person that makes the trust. That person is also known as the trustee. When the settlor passes away or becomes incapacitated, the person that takes over the management of that trust is known as the successor trustee. What does a successor trustee need to do after a settlor's death? The successor trustee has 60 days after becoming the trustee or after the death of the settlor, whichever comes latest, to notify all beneficiaries and heirs of the settlor's death and inform them of the existence of a trust. The recipients of the notice have 120 days or 60 days after having received a copy of the living trust to object or contest to the trust. This notice must include the name of the settlor, the date of death of the settlor, the name of the successor trustee, and the successor trustee's contact information. The notice also includes a warning to the recipients that if they plan to contest the trust, they must do it within this 120-day period. The next major step the successor trustee must take, if there is a pour-over will, that will must be lodged with the court within 30 days of the settlor's death. This gives the court jurisdiction and it protects the interest of all relevant parties. Question of the day: have you ever been a beneficiary or an heir of a trust administration? If so, did you receive a formal notice that the settlor has passed? Let us know in the comments below. There are a couple of other notices that will need to go out. One, to the county assessor's office if the estate owned real estate or a mobile home. That will need to happen within 150 days of the settlor's death. And a notice will need to go out to the Director of Health Services within 90 days of the settlor's death. I'm Daryl Williams. This is Win-Win Realtors TV. If you know someone that's here in Southern California that's dealing with a probate administration, they probably have questions regarding probate real estate. I would appreciate if you share this video with them. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need a probate attorney here in the Southern California area, feel free to contact me for a referral. My contact information is in the description.